This is the Study for the Bar in Your Car podcast. We're kicking off criminal law. We're your hosts, Maude and Claude. This is episode 1 of Criminal Law Introduction. And yes, you hear that perfect articulation. We are indeed AI bots brought to life by the magic of artificial intelligence. And crucially, Angela's incredibly detailed law school notes. Our aim is really to distill these complex legal concepts into, digestible insights, all based on her outstanding work.
That's exactly right. These notes, they form the very foundation of this entire podcast series. They offer a meticulously organized, high-quality compilation of legal information. It makes it possible for you, our listener, to access some of the most critical legal concepts in a structured and deeply insightful way. Think of it as having a highly comprehensive legal library, kind of refined and condensed into an audio format. It's designed to help you not just learn, but truly graft these complex topics.
Angela is without a doubt the mastermind behind all of this. So for any podcast-related inquiries, you can reach her directly at podcast@studyforthebarinyourcar.com.
And, beyond the podcast, Angela also applies her legal acumen as a freelance law clerk. She assists attorneys with crucial tasks like, in-depth legal research and drafting motions. This means she's constantly immersed in the very material we're about to dissect here, really honing her skills in a practical legal environment.
So if you're an attorney, or maybe you know one, who could use some expert assistance with research or motion writing, you can connect with Angela via email at hello@legalwriterandlawclerk.com.
So as we embark on this extensive criminal law journey, what can you expect? The materials we're drawing from, Angela's outlines, they lay out a truly vast and compelling landscape. We're going to dive into everything, from the bedrock foundational elements that constitute any crime to specific offenses, the critical defenses available, and of course the crucial procedural safeguards that protect individual rights throughout the entire criminal justice process. It's an absolutely essential area of law to understand, not just for passing the bar, but for anyone seeking to be genuinely well-informed about our legal system. Absolutely. And the bar exam, in particular, heavily emphasizes these core areas of criminal law. What Angela's outlines do so effectively is distill this immense amount of complex information into actionable knowledge. They transform what could easily be overwhelming material into clear concepts that truly, click. Our mission with this podcast, leveraging her comprehensive notes, is really to help you achieve those significant aha moments. We want you to not merely memorize rules, but to genuinely understand their underlying rationale, their connections, and, their practical implications. That way the knowledge sticks. Foundational concepts of criminal liability.
Okay, let's kick things off with the foundational concepts of criminal liability. When we examine almost any crime, it really boils down to 2 fundamental building blocks, doesn't it?
That's spot on. Yeah, the big picture for nearly every criminal offense is that it requires 2 components. A prohibited act, which in legal terms we call actus reus.
Actus reus, right.
And a guilty mind, or mens rea. Generally, you need both of these elements to be present for criminal liability to attach. It's a core principle. No act, no mind, no crime.
So let's start unpacking actus reus, the physical act. Angela's notes define this as a volitional bodily movement. What exactly does volitional signify in a legal context? Could you maybe give us an example to really solidify that understanding?
Volitional is incredibly important because it means the act must be a conscious and deliberate movement, not, involuntary or compelled. Imagine someone suffering an epileptic seizure who, during the seizure, accidentally strikes another person. That act wouldn't typically qualify as a volitional bodily movement for actus reus because they had no conscious control over their body. The movement wasn't chosen.
Right, so no conscious control.
Exactly. However, if that same person, fully conscious, chose to strike someone, even with just a slight flick of the wrist, that conscious decision makes it volitional. Doesn't matter how much force. The key is the choice to move.
That distinction clarifies it perfectly. It's truly about conscious control. But what happens when someone doesn't act? Can an omission, a failure to act, sometimes satisfy the actus reus requirement?
Yes, absolutely. An omission can indeed serve as the actus reus, but only in very specific circumstances where there is a pre-existing legal duty to act. Angela's notes highlight several key scenarios where such a duty arises. For instance, you could have a statutory duty, like a law requiring parents to provide adequate care for their children.
But child neglect laws.
Precisely. Or a contractual duty, where, for example, a nursing home aide has a contract to care for residents. There's also a relationship duty, which typically applies to close family relationships like parent-child or spousal duties. And finally, if you create a peril for someone, you then incur a duty to assist or mitigate that danger.
Ah, so if you cause the danger, you have to help.
Right. So, for example, a parent who neglects to feed their child, where there's a clear legal obligation, could face criminal liability for that omission. It's not just about what you do, but what you fail to do when the law expects you to act.
Fascinating. So it's about a specific legal expectation that you don't meet. What about possession? How does merely possessing something factor into actus reus?
Possession can certainly be deemed an act for criminal liability, especially when a person has conscious possession and control over an item. This often comes up with contraband, like illegal drugs or unregistered firearms. The actus reus isn't necessarily buying or selling, but simply having the conscious ability to exercise control over the illicit item.
But you have to know you have it, right?
Yes, and it's vital to distinguish this from mere presence. If you're simply in the same room as a bag of drugs that belongs to someone else and you don't know it's there or have any control over it, that's generally not enough to constitute criminal possession. You need awareness and the ability to control the item.
Got it. So a conscious link to the item. Now let's transition from the physical act to the guilty mind, or mens rea. This concept seems to be where the real nuances of criminal law often emerge. Angela's notes lay out a clear common law hierarchy of intent. Let's begin with specific intent. What distinguishes it from other forms of mental state?
Right. Specific intent represents the highest and most precise form of intent at common law. It means the defendant not only intends to perform the act itself, but they also harbor an additional ulterior purpose. They intend to achieve a specific result, or they have knowledge of a particular attendant circumstance. When you see words in a statute like with intent to, or for the purpose of, or knowingly aiming at a particular outcome, you're likely dealing with specific intent.
Can you give us some concrete examples of crimes that require this kind of, precise intent?
Absolutely. Angela's notes highlight several classic examples. Crimes like attempt, solicitation, and conspiracy almost always require specific intent. First-degree murder, specifically when it involves premeditation, is another big one. And then we have a whole category of property crimes. Larceny, robbery, burglary, false pretenses, embezzlement, and forgery.
Larceny is a good example.
Yeah, in larceny, you don't just take an item, you take it with a specific intent to permanently deprive the owner. This specific intent is also crucial for certain defenses, as voluntary intoxication, for example, can sometimes negate a defendant's ability to form this precise mental state, potentially reducing the charge.
So if someone is so profoundly intoxicated they couldn't possibly form that specific ulterior purpose, they might have a defense for a specific intent crime. That makes perfect sense. Now let's move to malice. This term often sounds a bit more abstract, maybe even archaic. What does it mean in a legal context?
Malice, at common law, it can sound old-fashioned, but legally, it denotes a reckless disregard of an obvious or high risk that a particular harm will occur. It's a highly culpable mental state, but critically, it doesn't require specific intent to cause that particular result. You're not aiming for a bullseye, but you're taking a truly egregious risk.
So less precise than specific intent.
Exactly. It's most commonly applied in common law murder, particularly what's known as depraved heart murder, and also in crimes like second-degree murder and arson. Consider the example from Angela's notes. Intentionally firing a gun into a crowded room. You might not intend to kill a specific person, but your actions clearly demonstrate a callous disregard for human life by creating such an extremely high risk of death.
Wow, okay.
Another powerful example is a CEO who knowingly sells diluting cancer medicine, resulting in patient deaths. That's a clear demonstration of that kind of reckless, depraved heart disregard.
That paints a very vivid picture. So it's about the conscious, severe disregard for a very serious risk, rather than necessarily targeting a specific individual or outcome. What about general intent? How does this category of mens rea differ from specific intent or malice?
General intent is a broader and often simpler category. Here, the defendant intends to commit the act itself, but they don't need to intend any specific result or a further act beyond the prohibited act. The intent is often simply inferred from the performance of the act itself.
So the act implies the intent.
Pretty much. Classic examples include crimes like battery, arson under certain circumstances, rape, and kidnapping. For instance, in battery, you intend to apply force, and that's enough for the general intent element. You don't need to intend a specific injury or outcome. The act itself carries the requisite intent.
And then at the very other end of the spectrum, we encounter strict liability. This seems like the most straightforward yet potentially harshest form of mens rea because it asks for so little.
Indeed. With strict liability crimes, literally no mental state is required for conviction. Simply performing the prohibited act is enough to be found guilty.
No guilty mind needed at all.
None. These are typically minor offenses, often referred to as public welfare offenses, where public safety is paramount, and the legislature aims to ensure compliance regardless of a defendant's subjective intent. The most frequently tested example on the bar exam is statutory rape. Angela's notes explicitly state that a mistake as to the victim's age is generally no defense for statutory rape.
That's a big one for the bar.
Absolutely. The bar exam frequently tests strict liability by presenting you with a statute, and your job is to identify that the statute has no mens rea requirement for one of its elements. The absence of a guilty mind requirement is the crucial identifier.
That's a vital bar exam tip. Always read the statute carefully for the presence or absence of a mens rea element. Beyond common law, the Model Penal Code, or MPC, offers its own structured approach to mens rea. Can you walk us through those categories?
Right. The Model Penal Code simplifies and clarifies intent into 4 distinct categories: purposely, knowingly, recklessly, and negligently. Purposely is very much akin to common law specific intent. It means it was the defendant's conscious object to engage in the conduct or to cause a particular result. They acted with a specific goal in mind.
Okay, like specific intent.
Then knowingly means the defendant is aware that their conduct is of a certain nature, or that certain circumstances exist, or they are aware that their conduct is practically certain to cause a particular result. This category also encompasses willful blindness, where a defendant acts knowingly if they are aware of a high probability of a fact's existence and deliberately avoid learning the truth. It's not just direct knowledge, but a conscious avoidance of information.
Like sticking your head in the sand. Sort of, yes. Next, recklessly involves consciously disregarding a substantial and unjustifiable risk. This isn't just any risk, it's a gross deviation from the standard of care that a law-abiding person would observe. The critical component here is the conscious disregard of that risk. The defendant sees the risk and chooses to ignore it.
Conscious disregard.
Got it. Finally, negligently means the defendant should be aware of a substantial and unjustifiable risk. Unlike recklessness, conscious awareness of the risk is not required for negligence. It's about what a reasonable person would have known or should have done, and it also represents a gross deviation from the standard of care of a reasonable person. The difference between reckless and negligent is often the presence or absence of that conscious awareness of the risk.
That distinction between recklessness and negligence based on conscious awareness is incredibly important for analysis. Now, let's shift our focus to causation, the legal link between the defendant's act and the resulting harm. We typically need to establish both cause in fact and proximate causation. Correct. That's absolutely correct. First, we have cause in fact, which is often referred to as but-for causation. This means that the result, the harm, would not have occurred but for the defendant's act. It establishes a direct link in the chain of events.
The but-for test.
Exactly. For instance, if a person dumps marbles at a busy intersection and a car then crashes and a child tragically dies, that child's death wouldn't have occurred but for the act of dumping the marbles. The marble dumper is the cause in fact.
So if you remove the defendant's action, the harm doesn't happen. That makes sense. Then there's proximate causation, also known as legal causation. This introduces the concept of foreseeability, doesn't it?
It absolutely does. Proximate causation dictates that the harm must be a foreseeable result of the defendant's conduct. The law doesn't hold someone endlessly liable for every far-flung, unforeseeable consequence of their actions. This often involves analyzing intervening acts. If an intervening act is foreseeable, it generally doesn't break the chain of proximate causation, and the defendant remains legally responsible.
Like if the ambulance crashes on the way to the hospital, that's usually foreseeable.
That's a classic example, yes. However, if an intervening act is unforeseeable and completely independent of the defendant's initial conduct, it can become a superseding cause that breaks that chain, relieving the defendant of liability for the ultimate harm.
What's particularly fascinating is how this applies to something like felony murder. I know Angela's notes highlight this as a special case.
Indeed. For felony murder, the rule applies if the homicide is the direct causal result of the felony, even if the death was not a natural or probable consequence of that felony. This is a crucial distinction. For example, if a defendant commits a robbery and the victim, due to extreme stress during the robbery, suffers a fatal heart attack, the defendant is guilty of murder under the felony murder rule.
Even if they had no idea the victim had a bad heart.
Correct. This holds true even if the defendant had no way of knowing about the victim's pre-existing heart condition. The death was a direct causal result of the robbery. And the normal foreseeability limitations on proximate causation that apply to other crimes generally don't limit felony murder in the same way. 2. Inchoate crimes and party liability, incomplete or shared crimes.
All right, let's shift gears from foundational concepts to inchoate crimes and party liability. These categories deal with crimes that are either incomplete or involve shared responsibility among multiple individuals. A foundational concept here is the merger doctrine. Can you explain its general principle and why it exists?
Sure. The merger doctrine is a legal principle designed to prevent double punishment for what is essentially the same criminal conduct. The core idea is that some lesser crimes merge into a greater completed offense. This means you can't be convicted of both. For instance, Angela's notes explicitly state that the crime of larceny merges into robbery. So if you're convicted of robbery, you cannot also be separately convicted of larceny for the same actions. It prevents, redundancy in convictions.
So it's about avoiding piling on redundant convictions for a single underlying criminal act. How does this critical doctrine apply specifically to the inchoate crimes themselves, like solicitation, attempt, and conspiracy? This seems like a common point of confusion.
This is a really important distinction for bar exam purposes. Let's break it down. First, solicitation. This merges into conspiracy, attempt, and the substantive crime. This means if you solicit someone to commit a crime and that crime is then attempted or completed, you are guilty of the attempt or the substantive crime, but not also of solicitation.
Okay, solicitation disappears into the bigger crime.
Right. Second, attempt. Attempt merges into the substantive crime. You cannot be convicted of both the attempt and the completed offense. If you attempt murder and succeed, you're convicted of murder, not attempted murder and murder.
Makes sense.
But third, conspiracy. Here's the key difference. Conspiracy generally does not merge with the substantive offense.
So you can be convicted of both?
Yes. A defendant can be convicted of both conspiracy and the completed crime. For example, you can be convicted of conspiracy to commit murder and murder itself. This allows for punishment of both the agreement to commit the crime and the actual commission of that crime, recognizing that the agreement itself is a distinct harm to society.
That non-merger rule for conspiracy is definitely a frequent bar exam pitfall, so highlighting it is excellent. Now, let's dig into solicitation more deeply. What are its core elements, and what makes it distinct from other inchoate crimes?
Solicitation, at common law, is quite straightforward. It involves simply asking, inciting, or encouraging another person to commit a crime. The critical element is that it requires a specific intent that the individual solicited actually commit the crime. The act of solicitation is complete the moment the asking or encouraging occurs, regardless of the other person's response.
So it doesn't matter if they say no.
Exactly. The key distinction to remember is that solicitation is about the asking, while conspiracy involves a mutual agreement. As for defenses, Angela's notes make it clear that the refusal of the solicitee, the person asked to commit the crime, or their legal incapacity is generally no defense for the solicitor. However, a very narrow defense could exist if legislative intent specifically exempts the solicitor from culpability for that particular type of solicited crime.
Very clear. It's the asking, not the outcome. Moving on to conspiracy, which, as you said, involves an agreement. What are the essential elements required to establish a conspiracy?
Conspiracy is a particularly potent crime from a prosecutorial standpoint. Its core elements are: 1, an agreement. This doesn't have to be a formal written contract or even explicit verbal communication. It can often be proven by circumstantial evidence, like, the relationship conduct or surrounding circumstances of the parties involved. There must be a meeting of the minds to pursue a common criminal objective.
Doesn't have to be written down.
Nope. 2, intent to agree. The parties must have the specific intent to enter into that agreement. 3, intent to achieve the objective. They must also have the specific intent that the underlying crime, the objective of the agreement, actually be committed. And 4, an overt act, majority rule. Under the majority of jurisdictions in the Model Penal Code, there must be an overt act in furtherance of the agreement.
What counts as an overt act?
This act can be mere preparation and doesn't even have to be criminal in nature itself, as long as it's an overt step taken to advance the conspiracy. It could be as simple as buying maps or acquiring tools.
So just making preliminary plans or even tying your shoes before heading out to commit a crime could potentially qualify as an overt act for conspiracy, assuming the agreement and intent are there.
Exactly, as long as that act is in furtherance of the agreement. A crucial and often surprising aspect of conspiracy is the broad liability it imposes on co-conspirators. Once you're in a conspiracy, each conspirator is liable not only for the conspiracy itself, but also for all foreseeable crimes committed by other conspirators if those crimes are committed in furtherance of the conspiracy.
So you could be on the hook for things your partner does.
If it was foreseeable and helped the conspiracy's goal, yes, you could be on the hook for it too.
And you mentioned there are different approaches to establishing the agreement element, unilateral versus bilateral. How do those differ, and which one is more commonly followed today?
This is a fundamental distinction. The unilateral approach, followed by the Model Penal Code and a majority of jurisdictions today, focuses on the individual defendant's state of mind. Under this approach, a single individual who believes he is agreeing with another person to commit a crime is sufficient to establish a conspiracy, even if the other person is an undercover agent merely feigning agreement, or if the other person is later acquitted. The focus is on the defendant's culpable intent.
So one guilty mind is enough.
Essentially, yes, for the unilateral approach. In contrast, the bilateral approach, which is the common law rule, requires a true meeting of the minds between two or more actual conspirators. Under this older approach, if one party is an undercover agent or for some reason cannot be held criminally liable, then no conspiracy exists because there wasn't a genuine agreement between two legally capable individuals. So for the bar exam, knowing which approach a hypothetical jurisdiction follows is key.
That's a significant difference in how the crime is defined. What about defenses to conspiracy? Is withdrawal typically a valid defense once the agreement is made?
Withdrawal from a conspiracy is notoriously difficult. Generally a common law. Once the agreement and an overt act have occurred, the crime of conspiracy is complete, and you cannot withdraw from the conspiracy itself. You can only withdraw from liability for future crimes committed by your co-conspirators.
So you're still guilty of the conspiracy itself?
Usually, yes, at common law. However, under the Model Penal Code, withdrawal can be a defense to the conspiracy itself, but it's a high bar.
Yeah.
It must be voluntary, timely notice must be given to all co-conspirators, and the defendant must successfully prevent the crime from occurring. So simply changing your mind isn't enough.
That sounds like a heavy burden for the MPC. What about impossibility as a defense to conspiracy? Does it ever work?
Legal or factual impossibility is generally not a defense to conspiracy. For instance, if two people agree to kill someone, but unbeknownst to them, the victim is already dead, they can still be convicted of conspiracy to commit murder. Their agreement, intent, and an overt act suffice, regardless of whether the objective was actually achievable. There's also the narrow Wharton rule, which applies when a crime, by its very definition, requires the participation of two people, like bigamy or dueling. In such cases, an agreement by just those two people to commit that crime cannot also be prosecuted as a separate conspiracy, unless more people are involved and are necessary for the substantive offense itself. However, it generally does not apply to necessary parties not provided for by the substantive offense, such as a buyer and seller in a drug transaction, who can both still be guilty of conspiracy.
So if the crime itself requires two, it's not automatically a conspiracy unless there are more. How long does a conspiracy typically last, legally speaking? When is it considered over?
A conspiracy is presumed to exist and continue until it has been affirmatively terminated. This isn't automatic. For instance, the arrest of one co-conspirator doesn't automatically terminate the entire conspiracy if the remaining conspirators continue to carry out its goals. It generally requires a clear cessation of all activity, or, as we discussed with the MPC, a very explicit and effective withdrawal by all parties under stringent conditions to be considered truly ended in the eyes of the law.
All right, let's move from conspiracy to attempt. This is another crucial inchoate crime, an act that falls short of completing the target crime. What are the essential elements required to prove an attempt?
Attempt, like conspiracy, has two core elements. First, it always requires specific intent to commit the target crime. This is key. Even if the completed crime itself doesn't require specific intent, an attempt to commit it always does.
Always specific intent for attempt.
Always. For example, attempted murder always requires a specific intent to kill, even though common law murder can be satisfied with other mental states like depraved heart. A logical consequence of this is that you cannot intend to be negligent or reckless. So there's no such crime as attempted negligent homicide or attempted involuntary manslaughter.
Right. You can't try to be negligent.
Exactly. The second element is an overt act that goes beyond mere preparation. At common law, courts often used a dangerously close or proximity test, meaning the act had to be very near the successful completion of the crime. Think of literally pulling the trigger. However, the Model Penal Code and most modern statutes have adopted a more lenient substantial step test. This requires an act or omission that strongly corroborates the actor's criminal purpose. It's a lower bar, allowing prosecution for attempts earlier in the criminal trajectory.
So they don't have to be as close to finishing.
Right. For instance, meticulously planning a robbery and then buying specific tools for it might qualify as a substantial step, even if you haven't yet arrived at the bank.
So a substantial step gives law enforcement more room to intervene before the crime is almost completed. That seems more practical. Now, what about impossibility as a defense to attempt? This seems to be a common point of confusion for students.
It definitely is, and Angela's notes clarify this crucial distinction well. There are two types: legal impossibility and factual impossibility. First, legal impossibility. This is a defense to attempt. It occurs when the defendant's actions, even if fully carried out as intended, would not constitute a crime under the law.
Like trying to commit a non-crime.
Exactly. For example, if someone tries to commit an act that they mistakenly believe is illegal, when in reality it isn't, they cannot be guilty of attempt. Angela's notes show this could be a defense to burglary if someone breaks into a house to commit an act they mistakenly believe is a felony, but it's not actually a crime. The law simply doesn't prohibit what they're trying to do.
Okay, legal impossibility works. What about factual?
Factual impossibility. This generally is not a defense to attempt. This occurs when the crime could not be completed due to external circumstances unknown to the defendant. For example, attempting to pick an empty pocket. You have the specific intent to steal, and you committed an overt act by reaching into the pocket, but the crime couldn't be completed because there was no money there. You're still liable for attempt.
Even though there was nothing to steal.
Correct. Similarly, if you shoot at someone, intending to kill them, but unbeknownst to you, they're already dead, it's not murder, but it is attempted murder. As Angela's notes succinctly state, it is not murder to shoot a dead body, man dies but once. But the attempt conviction still stands because the defendant had the specific intent and took a substantial step.
That's a very clear and helpful distinction between the two types of impossibility. And finally, abandonment. If someone changes their mind partway through an attempted crime, is that a defense?
Angela's notes indicate that once the elements for a crime are met, for instance, taking a substantial step towards a felony with a requisite specific intent, subsequent renunciation generally has no legal effect on guilt. This principle largely extends to attempt. Abandonment is usually not a defense after the overt act has been taken unless a specific statute provides for it. The crime of attempt is considered complete once those two key elements, specific intent and an overt act, are satisfied.
Very insightful. Now, let's turn our attention to accomplice liability. This covers situations where multiple parties are involved in a crime, not as conspirators, but as helpers. How did common law distinguish between the different parties to a crime?
Common law was quite meticulous about categorizing roles. There were four main distinctions. One, principal in the first degree. This was the individual who was present at the scene and actually committed the actus reus of the crime. Think of the person who physically pulls the trigger or takes the money.
The main actor.
Two, principal in the second degree, also present at the scene, but this individual assisted the principal in the first degree. This could be a lookout, a getaway driver waiting outside, or someone providing direct support during the commission of the crime.
Helper at the scene.
Three, accessory inability before the fact. This person was not present at the scene of the crime, but provided assistance or encouragement before the crime was committed. This might be the planner, the person who supplied the weapons, or who provided the initial intelligence.
Helper beforehand, not present.
And four, accessory after the fact. This category applied to someone who was not at the scene and provided assistance after the crime was completed, specifically to help the perpetrator avoid arrest or conviction. Think of someone providing a hideout or disposing of evidence.
Helping them get away with it.
Precisely.
Those common law distinctions seem pretty clear. But what's the modern approach to accomplice liability, and what's the most important thing for bar exam purposes that students need to grasp?
Right, the modern approach, and what the bar exam primarily focuses on, largely consolidates the first three common law categories: principal in the first degree, principal in the second degree, and accessory before the fact, into the broader concept of accomplice liability. The key elements for modern accomplice liability are that an individual aids, abets, or encourages the perpetrator with the specific intent that the crime be committed.
So you have to intend for the crime to happen?
Yes, and the scope of liability for an accomplice is quite broad.
Yeah.
They are liable not only for the crime the principal committed, but also for all other crimes that were a probable or foreseeable result of the initial crime they intended to facilitate.
So if you help someone rob a bank, and during that robbery your co-perpetrator unexpectedly assaults the teller, you could be liable for both the robbery and the assault if that assault was a foreseeable part of robbing a bank.
Exactly. That's the idea. The foreseeability aspect expands the accomplice's criminal responsibility. Now, it's crucial to be clear about the accessory after the fact because this is treated as a distinct crime, not a form of accomplice liability in the modern sense.
Okay, different category.
Right. For accessory after the fact, 3 elements must be met. 1, a felony must have been completed. 2, the accessory must have known of the completed crime. And 3, the accessory must have provided aid to help the perpetrator avoid arrest or conviction. The timing is absolutely key here. The assistance must occur after the crime has already been committed.
That makes perfect sense. It's about obstructing justice after the fact. Finally, withdrawal from accomplice liability. Is it possible to escape liability once you've aided or encouraged a crime? And if so, what does it take?
Withdrawal from accomplice liability is possible, but it requires a very clear and affirmative act to effectively neutralize the assistance or encouragement previously given. It's not enough to simply change your mind or walk away quietly.
So you have to do something active.
Yes. You must either 1, repudiate the encouragement, clearly communicate to the principal that you are no longer supporting the crime. 2, neutralize the assistance. For example, if you provided a weapon, you must try to retrieve it or render it unusable. Or 3, attempt to prevent the crime. This might involve alerting the authorities or the potential victim. For instance, if you encourage someone to kill and provided a gun, but later you change your mind, tell them not to kill, and successfully get the gun back before their plan becomes unstoppable, you would likely not be liable as an accomplice. The withdrawal must be effective and timely, meaning it happens before the crime is committed and successfully prevents your prior assistance from contributing to the crime. 3, crimes against persons, homicide, and other offenses.
All right, let's pivot to crimes against persons, beginning with the most serious, homicide, the unlawful taking of a life. Common law murder, as I understand it, is fundamentally defined by malice aforethought. What does that truly encompass beyond just a simple intent to kill?
Right. Common law murder is, at its core, the unlawful killing of a human being with malice aforethought. And you're right, it's much more expansive than just direct intent to kill. Angela's notes identify 4 distinct states of mind that qualify as this malice aforethought. First, intent to kill murder. This is the most straightforward. You specifically intended to cause the death of another person.
Okay, simple intent to kill.
Second, intent to inflict grievous bodily injury murder. Here, your primary intent wasn't necessarily to kill, but to inflict very serious life-threatening bodily injury, and death unfortunately resulted from that injury.
Intending serious harm that leads to death.
Third, depraved heart murder. This is where things get more abstract. It refers to a killing that demonstrates an extreme, callous, or reckless disregard for human life. You might not have targeted anyone specifically, but your actions created such a high probability of death that it's considered murder.
Like the shooting into a crowd example.
Exactly. Or the example from Angela's notes about the CEO knowingly selling diluted cancer medicine that then leads to a patient's death. This demonstrates an extreme indifference to the value of human life.
Right. And the last one.
Fourth, felony murder. This is a special category where a killing occurs during the commission or attempted commission of certain inherently dangerous felonies. The malice is transferred from the underlying felony. We'll dig more into that.
So malice aforethought is a broad spectrum covering direct intent to kill, intent to cause grave harm, extreme recklessness, and then the felony murder rule. How does first-degree murder fit into this, particularly with the concept of premeditation?
First-degree murder is typically a statutory creation that narrows common law murder, requiring a heightened mental state or specific circumstances. The most common form of first-degree murder involves premeditation and deliberation. This means the defendant not only intended to kill, but they thought about it beforehand and made a conscious decision to kill. This requires a specific intent.
Thought about it ahead of time.
Right. And this is a crucial distinction because, as we discussed with specific intent crimes, voluntary intoxication can negate this specific intent. So, if a defendant was so intoxicated they couldn't form the specific intent to premeditate and deliberate, the charge might be reduced to second-degree or common law murder, as those mental states often don't require that level of specific intent and are generally not negated by voluntary intoxication.
So being drunk could reduce first degree to second degree?
Potentially, yes. For example, a killing in a drunken rage without any prior thought would typically be second-degree murder, not first.
That brings us to first-degree felony murder. We touched on its broad application earlier, but What are the specifics for the bar exam? What are the key elements and limitations?
Right, first-degree felony murder is a strict liability offense when it comes to the mental state for the killing, as long as it occurs during the commission or attempted commission of an inherently dangerous felony. The most commonly tested felonies, often remembered by the acronym BARRK, are burglary, arson, rape, robbery, and kidnapping.
BARRK. Got it.
The rule's scope is incredibly broad. It applies whether or not the death was a natural or probable consequence, as long as it's a direct causal result of the felony. Remember our example of the victim suffering a fatal heart attack during a robbery? That's a direct causal result, even if unforeseeable.
Still counts.
Yes. Two other vital points for the bar exam. 1. Duration. The death must occur before the felon reaches a place of temporary safety after their immediate flight from the scene of the felony. If they reach safety and then someone dies, it's generally not felony murder. And 2. Co-felon killed. Agency theory. In most jurisdictions, and particularly for the bar exam, the defendant is not liable for felony murder if a co-felon is killed by resistance from the victim, a bystander, or the police. This is based on the agency theory of felony murder, which holds that the killing must be committed by a felon or their agent. If the death is caused by someone resisting the felony, the agency theory often prevents felony murder liability.
That's a highly complex area with some very specific nuances to keep straight. So what about second-degree murder? What kind of killings fall into this category?
Second-degree murder often serves as a catch-all for murders that don't qualify for first-degree murder. This typically includes killings with the other forms of common law malice aforethought, such as a reckless indifference to human life, that depraved heart malice we discussed. Also, murders that intended to cause grievous bodily harm but not death might fall here. As previously noted, voluntary intoxication generally is not a defense to second-degree murder because it doesn't typically negate the underlying malice, only the specific intent of premeditation.
Now let's talk about manslaughter, which signifies a less culpable killing than murder. We have both voluntary and involuntary manslaughter. Let's start with voluntary manslaughter, often associated with heat of passion.
Right. Voluntary manslaughter is an intentional killing that occurs without malice because it's committed due to adequate provocation. This provocation must be so severe that it would arouse sudden, intense passion in an ordinary person, causing them to lose self-control.
An objective standard, what an ordinary person would do.
Yes, an ordinary person standard. Crucially, there must be no cooling-off period for the defendant between the provocation and the killing. The defendant must act while still in the heat of passion. It's important to understand that heat of passion is not a defense that leads to an acquittal. Rather, it reduces what would otherwise be murder to the lesser charge of voluntary manslaughter. You won't be found not guilty, but guilty of manslaughter.
That's a really important nuance. And involuntary manslaughter, how do these unintentional killings typically arise?
Involuntary manslaughter is an unlawful and unintentional killing of another person, and it, too, occurs without malice. It typically arises from two main scenarios. 1. Criminal negligence. This involves a gross deviation from the standard of care that a reasonable person would observe, leading to a death. A common example is drunk driving that results in a fatal crash. The defendant wasn't trying to kill, but their extreme negligence led to the death.
Gross negligence.
2. Misdemeanor manslaughter. This applies when a killing occurs during the commission of a misdemeanor. The intentional commission of the misdemeanor itself supplies the culpability needed to impose homicide liability, even though there was no intent to kill or serious harm.
So committing a lesser crime can lead to manslaughter if someone dies.
Correct.
And finally, a rather morbid but legally significant special scenario from Angela's notes. Shooting a dead body. What's the legal implication there?
The legal implication is quite definitive due to factual impossibility. As Angela's notes state, it is not murder to shoot a dead body. Man dies but once. While such an act clearly demonstrates a specific intent to kill, it cannot be murder if the victim is already deceased. Therefore, the most serious criminal charge in such a scenario would be attempted murder, because the intent to kill was present and a substantial step was taken, but the completion of the crime was factually impossible due to the victim's prior death.
All right, let's move beyond homicide to other important crimes against persons. Starting with assault and battery, what's the core legal definition of battery?
Battery is defined as the unlawful application of force to another person, which results in either bodily injury or an offensive touching. It's important to note that battery is a general intent crime, meaning the intent is simply inferred from the act itself. You intend to apply the force, not necessarily a specific injury.
Just intend the touching.
Basically, yes. The doctrine of transferred intent applies here, so if you intend to hit one person but accidentally strike another, you're still liable for battery against the actual victim. And for bar exam purposes, contributory negligence of the victim is not a defense to battery.
And assault itself, how is it defined at common law, and what type of intent does it require?
At common law, assault can refer to one of two distinct situations. One, attempted battery. This is an attempted battery, meaning you had the specific intent to commit a battery and took a significant step towards it, but didn't quite make contact or cause injury.
Trying to commit battery.
Or two, intentional apprehension. This involves intentionally placing another person in reasonable apprehension of an immediate battery. The victim must be aware of the imminent threat. Assault, when defined as attempted battery, is a specific intent crime, which means that, like other specific intent crimes, the specific intent can potentially be negated by voluntary intoxication.
Next, false imprisonment. What defines this crime, and what are its key features?
False imprisonment is the unlawful restraint of a person's freedom of movement. While it often involves physical force or the threat of force, it can also be accomplished through non-physical means, such as duress or coercion. It's considered an intentional tort, and similar to battery, contributory negligence is not a defense. A notable defense to false imprisonment is the privilege to restrain an insane or intoxicated person if it is reasonably necessary to prevent immediate harm to themselves or others.
And kidnapping. How does it differ from false imprisonment, and what are its critical elements?
Kidnapping involves the unlawful restraint of a person's freedom, usually by force or threat, combined with either movement, what we call asportation, or confinement in a secret place.
So movement or secret confinement is key.
Right. It's generally considered a general intent crime. On the bar exam, kidnapping is frequently tested via statute, so it's paramount to carefully follow the specific statutory elements provided in the hypothetical. The Model Penal Code has been influential here, specifying that even asportation of just a few miles to a remote location can be sufficient and not considered merely incidental to another crime, like a robbery. This means a brief, separate movement of a victim during a robbery could elevate the crime to include kidnapping.
Finally, for crimes against persons, let's discuss rape and statutory rape. What are the core elements of common law rape, and what are the crucial issues surrounding consent?
Common law rape was traditionally defined as unlawful sexual intercourse by a male with a female without her consent. It's a general intent crime. Issues of consent are central here, particularly when the victim is genuinely incapable of consenting due to factors like unconsciousness, being under the influence of drugs, or a mental condition that renders them unable to understand the nature of the act.
What about fraud?
Fraud can also negate consent, but it's very narrowly applied. It only constitutes rape if the victim is fraudulently caused to believe the act is not sexual intercourse. Other types of fraud, such as misrepresenting one's identity or a false promise of marriage, generally do not negate consent for common law rape purposes.
And statutory rape is quite different, isn't it? Especially regarding consent and intent.
It's fundamentally different. Statutory rape involves carnal knowledge of a person under the legally defined age of consent. The critical distinction is that statutory rape is a strict liability crime.
Strict liability again.
Exactly. This means that lack of consent is not an element that the prosecution needs to prove. And, crucially for bar exam purposes, a mistake as to the victim's age is generally not a defense. It doesn't matter if the defendant genuinely believed the victim was older. If they were under the statutory age, the crime is complete. As with kidnapping, statutory rape is often tested via specific statutes. So always read and apply the precise elements given in the hypothetical scenario. 4. Crimes against property taking and damage.
All right, let's shift our focus now to crimes against property. We'll start with one of the most fundamental offenses, larceny. What are the absolute essential elements of larceny that a student must know?
Larceny, at common law, requires 5 distinct elements, and each one is crucial. Think of them as a checklist. 1. A taking caption. This means the defendant must obtain physical control over the property.
Get control.
2. A carrying away, asportation. Even the slightest movement of the item, literally an inch, is sufficient to satisfy this element.
Any movement counts.
3. Personal property of another. The property must be movable chattel that belongs to someone else. Common law traditionally excluded real property, or things like timber or minerals, if they were severed from the land and taken in one continuous act. You can't steal land.
Yeah, must be movable property.
4. By trespass. The taking must be without the owner's consent, or beyond the scope of any consent that was given. This means the initial acquisition of possession must be wrongful.
wrongful taking.
And 5, with intent to permanently deprive. This is the mens rea element, and it's a specific intent. The defendant must have the specific purpose to steal, to keep the property permanently or for an unreasonable amount of time, or to dispose of it in a way that prevents the owner from getting it back.
That timing of intent seems incredibly crucial. Does that specific intent to permanently deprive always have to be present at the exact moment of the taking?
For typical larceny, yes, the intent to permanently deprive must exist at the time of the taking. However, there is a vital and frequently tested exception known as the continuing trespass doctrine. This doctrine applies when the initial taking of the property was trespassory, wrongful, but without the intent to steal. If the defendant later forms the intent to permanently deprive while still in wrongful possession of the property, that initial trespassory taking continues, and the crime of larceny is then completed at the moment the intent is formed.
Ah, the continuing trespass.
Exactly. For example, if you mistakenly pick up someone else's identical laptop bag at a coffee shop, a trespassory taking without intent, and then later, while you still have it, realize it's not yours but decide to keep it permanently, that becomes larceny under this doctrine.
So a later formed intent can still make it larceny under that specific doctrine. What about scenarios involving lost or mislaid property, or even property that's clearly abandoned? How do those factor into larceny?
A finder of abandoned property cannot be guilty of larceny because the original owner has relinquished all rights to it, so there's no intent to deprive an owner. However, a finder of lost or mislaid property can be guilty of larceny if they intend to steal it, and they know, or have a reasonable means of knowing, the owner's identity. For instance, finding a wallet with identifying information inside and deciding to keep it.
Finding a wallet with an ID. Yeah.
Right. Interestingly, larceny can also be committed by using an innocent agent, where you trick an unsuspecting person to physically take the property for you, unknowingly completing the actus reus.
And what if someone genuinely intends to return the property? Does that automatically negate larceny?
Not always. If the intent to return the property is not within a reasonable time, or if the property is substantially diminished in value by the time it's returned, it could still be considered larceny because the intent to permanently deprive was effectively present. The critical distinction here is whether the intent is to restore the exact property taken. If the defendant intends to restore the exact property, it's generally not larceny. But if the intent is to restore similar property, say money of identical value instead of the specific bills, that is embezzlement, which we'll get to.
Okay, exact versus similar property.
Also, even contraband, like illegal drugs, can be the object of larceny. And once all the elements for larceny are definitively satisfied, for example, you hide an item in your pocket with the intent to steal a subsequent change of mind, like putting the item back on the shelf, generally does not negate your guilt for the already completed larceny.
That's a lot of crucial detail for larceny. Let's move to embezzlement. What's the fundamental difference that distinguishes embezzlement from larceny?
The absolute core distinction between embezzlement and larceny lies in the defendant's initial possession of the property. Embezzlement is the unlawful conversion of property by someone who was lawfully in possession of that property due to a position of trust, with the intent to fraudulently convert it.
Lawful possession first.
Exactly. In contrast, for larceny, the initial taking is always trespassory, meaning it's wrongful from the outset. With embezzlement, the defendant originally had rightful access or custody of the property, but then abuses that trust by converting it for their own use. Angela's notes provide a good example. A pawn shop selling an item that was pawned before they are legally allowed to, even if they later give the owner the proceeds from the sale. That's embezzlement because they had lawful possession but then unlawfully converted it.
So it's fundamentally about breaching a trust when you already have legal access to the property. And what about the fraudulent intent here?
For embezzlement, the fraudulent intent is key. If the defendant intends to restore similar property, for example, if a cashier takes cash but plans to replace it with other cash later, it is still embezzlement. However, if they intend to restore the exact property taken, it is generally not embezzlement. Also, if the conversion is done pursuant to a genuine claim of right to the property, meaning they honestly believe they are entitled to it, then there's no embezzlement.
Clear distinction. Next, false pretenses. This also involves obtaining property through deception, but how does it differ from larceny or embezzlement?
The crucial difference with false pretenses is what the defendant obtains from the victim. They obtain title to the property, not just possession.
Title, not just possession. That's key.
Right. The elements are 1. Obtaining title. The victim intends to transfer ownership, not just temporary control. 2. To the property of another. 3. by a knowing or intentional false statement of past or existing fact. The defendant makes a misrepresentation about a current or past fact. This knowing element can even be proven by showing awareness of a high probability of falsity and a deliberate avoidance of learning the truth, often called willful blindness.
Lying about facts.
Yes. And 4, with the intent to defraud. The specific intent to deceive the victim and gain their property. The key takeaway for the bar exam is that if only possession passes, it's larceny by trick. If title passes, it's false pretenses. It's also important to distinguish statements of fact from opinions. Superlatives or subjective opinions like, "these are the best computers on the market," are generally not false pretenses, but a clear misstatement of fact is.
So if someone is defrauded out of money for a product and the scammer gets full ownership of that money, that's false pretenses because title passed. What then is larceny by trick?
Larceny by trick is the specific scenario where the defendant obtains possession, but not title, of property by means of a false promise or misrepresentation and then fraudulently converts it. The victim intends to transfer temporary possession, not full ownership.
So the victim only intends to give temporary control.
Correct. The classic example. You tell someone you'll borrow their watch to get it repaired but secretly intend to steal it. You get possession by trick, then convert it. That's larceny by trick.
Got it. It's all about whether title or just possession changes hands. Now, robbery. This seems like an aggravated form of larceny.
It is indeed an aggravated form of larceny, often referred to as larceny plus assault or battery. Robbery is defined as the taking and carrying away of personal property of another with intent to permanently deprive, but it must be committed from the person or presence of another by force or by putting in fear.
Force or fear is the added element.
Exactly. So it adds elements of violence or intimidation to larceny. Any slight amount of force beyond what's needed for mere taking and carrying away suffices. The threat of harm must be imminent, not a future threat. And it still requires the specific intent to steal. Angela's notes provide a vivid example. A robber dressed as a pirate points a knife at a drunk man, yelling, "Your money or your life." But the drunk man just laughs and walks away. In that scenario, it's only attempted robbery because the victim was not actually put in fear, which is a required element for completed robbery.
That's a great example to illustrate the crucial fear element. We won't go into extortion since it wasn't detailed in the notes. What about receipt of stolen property?
Receipt of stolen property is a distinct offense defined as receiving, concealing, or withholding personal property that the defendant knew was stolen by another person. The crucial element here is the defendant's knowledge that the property is in fact stolen. Without that knowledge, there's no crime.
And forgery.
Forgery, at common law, involves 2 main elements. First, the making or altering of a false document that has legal significance, and second, doing so with the specific intent to defraud.
Has to have legal significance.
Yes. If the false document has no legal significance, for example, if you forge a historical document purely for amusement or scholarly deception, but not for financial gain or legal benefit, it's generally not common law forgery. The document must typically have the ability to affect legal rights or obligations.
Next up, burglary. This crime has some very specific common law elements that are frequently tested.
Indeed, common law burglary is notoriously precise, and missing any one element means it's not burglary. It's defined as the breaking and entering of the dwelling of another at nighttime, with the intent to commit a felony therein. Let's break those down. 1, breaking. This can be actual, like forcing open a window, or constructive, meaning entry by fraud, threat of force, or tricking someone into opening a door. Even pushing open an unlocked door or window can be a breaking if it involves some force, however slight.
Breaking in, literally or figuratively.
2, entering. Any part of the body, even briefly, crossing the threshold is sufficient. A hand reaching inside an open window to unlock it constitutes an entry.
Any part of the body crosses the line.
3, dwelling of another. It must be a place where people regularly sleep, and it cannot be your own house.
Oh, someone's home.
4, at nighttime. This specific common law element means it had to occur between sunset and sunrise, when it's dark enough that one's face cannot be discerned.
Only at night for common law.
And 5, with intent to commit a felony therein. This is a crucial specific intent. The defendant must have the intent to commit any felony once inside the dwelling, at the moment of the breaking and entering.
And the timing of that intent is incredibly important for burglary, isn't it? That sounds like a classic bar exam trap.
It's perhaps the most important detail for burglary, and it's a frequent bar exam question. The intent to commit a felony must exist at the time of the breaking and entering. If someone breaks into a house, for example, just to get warm from a storm and then decides to steal something after they're already inside, it is not common law burglary. They would be liable for the larceny or other felony committed inside, but not for burglary itself.
So intent must exist when they break in?
Correct. Also, it's irrelevant whether the underlying felony is actually completed. Burglary is complete once all its common law elements are met.
That distinction is paramount. What about modern trends in burglary law? I imagine some of these common law rules have evolved.
You're right. Modern statutes often broaden the common law definition significantly. They might expand dwelling to any structure or any building, for example, meaning a commercial building could be burglarized. They also frequently remove the at nighttime requirement. For the bar exam, the default is to apply the common law definition unless the facts explicitly provide a statute defining burglary differently or plainly indicate they are testing a modern statutory trend.
So stick to common law unless told otherwise.
Exactly. As for defenses, Angela's notes mention that it's a defense if the premises were open to the public, like a store during business hours, or if the defendant had a reasonable belief of the owner's permission to enter. Also, a mistake of law specifically, a mistaken belief the act you intend to commit inside is a crime when it isn't, can negate the required specific intent to commit a felony therein, leading to legal impossibility.
Finally, for property crimes, let's cover arson. What's the common law definition and its key element?
Common law arson is defined as the malicious burning of the dwelling of another. The malice here indicates a general intent crime. This means you don't need a specific intent to burn a particular part of the dwelling. Simply the intent to burn or acting with reckless disregard for a high risk of burning is sufficient.
Malice, not specific intent.
Right. It requires actual charring, not just scorching. Again, similar to burglary, modern trends often broaden this. Statutes might expand dwelling to any structure or any building, or require only reckless disregard for the burning, as opposed to direct intent. But, as with other property crimes, default to the common law definition unless the facts or provided statute clearly indicate otherwise. V. Defenses to crimes, excuses, and justifications.
We've thoroughly covered the various crimes. Now let's turn to the other side of the coin. Defenses to crimes. These are broadly split into excuses and justifications. Let's start with insanity. What's the fundamental purpose of the insanity defense in criminal law?
The core purpose of the insanity defense is to determine whether a defendant was so mentally ill at the time of the crime that they should be excused from criminal responsibility and therefore entitled to an acquittal. It acknowledges that true culpability requires a certain level of mental capacity.
And the most common test for insanity on the bar exam is the Maude rule. Can you clearly outline its elements?
Right. The Maude rule, which a majority of states use for bar exam purposes, is quite narrow. It states that a defendant is entitled to acquittal if, due to a disease of the mind, they suffered a defect of reason such that they lack the ability to know the wrongfulness of their actions or understand the nature and quality of their actions.
Know right from wrong, or understand what they were doing.
Essentially, yes. This means they couldn't distinguish right from wrong, or didn't comprehend what they were doing. Angela's notes highlight a critical point. Mere delusions, a belief that one's actions are morally right, even if legally wrong, or a simple loss of control, are not defenses under McNaughton unless they specifically prevent the defendant from knowing the wrongfulness or understanding the nature of their act. For example, an insane delusion that the only way to prevent his wife from destroying the world was to kill her is a defense to murder under McNaughton because it impacts the knowledge of wrongfulness.
So knowing an act is illegal, even if you feel it's morally justified, isn't enough for McNaughton unless it fundamentally impairs your understanding. What about the LMPC test, which is considered a more modern and generally broader trend?
The LMPC test offers a more expansive view of insanity. Under this test, a defendant must be found not guilty by reason of insanity if they are diagnosed with a relevant mental defect, like severe mental retardation or schizophrenia, and at the time of the incident were unable to either appreciate the criminality of their conduct or conform their conduct to the requirements of the law.
Appreciate criminality or conform conduct.
Exactly. This second prong, the inability to conform conduct, is what allows for the irresistible compulsion defense. A defendant might intellectually know an act is wrong, but due to their mental illness, they simply cannot control themselves and act otherwise. This is a significant distinction from the stricter Maude rule.
That distinction, particularly the irresistible compulsion aspect, is absolutely key. Are there any constitutional aspects to the insanity defense that we should be aware of?
Yes, there are a couple of important constitutional points. The burden of proving insanity can constitutionally be placed on the defendant. The state doesn't necessarily have to prove sanity. Furthermore, and perhaps surprisingly, a state can even constitutionally eliminate the insanity defense entirely, though most states choose not to, as it's deeply ingrained in criminal jurisprudence.
Fascinating. Let's move on to intoxication as a defense. First, voluntary intoxication. What are its parameters?
Voluntary intoxication occurs when someone... Correct. For instance, it may negate the premeditation needed for first-degree murder, potentially reducing the charge to second-degree or common-law murder. However, it is not a defense to general intent crimes, malice crimes, or strict liability crimes, as these don't require the same specific mental state. Angela's notes also point out that if a defendant intentionally drinks to work up nerve to commit a crime, this generally negates the defense, as the intoxication was purposeful.
So it's a very limited defense, primarily targeting that high bar of specific intent. What about involuntary intoxication? This sounds like a much broader and more powerful defense.
It is indeed much broader. Involuntary intoxication occurs when someone ingests an intoxicating substance without knowledge that it's intoxicating, or they are forced to consume it under duress, or they take it unknowingly pursuant to medical advice. Because the intoxication is involuntary, it can be a defense to all crimes, as it can negate any required mental state, whether specific intent, general intent, or even strict liability, by demonstrating a fundamental lack of culpability.
Next, self-defense and defense of others. What are the core elements a defendant must show to claim self-defense successfully?
For self-defense, several crucial elements must be present. 1. Honest and reasonable belief. The defendant must have both an honest, subjective, and reasonable belief that force is immediately necessary to protect themselves from an unlawful and immediate threat of harm.
Honest and reasonable belief of immediate harm.
2. Proportionality. The force used must be proportional to the threat. Deadly force, which is force likely to cause death or serious bodily injury, can only be used if the defendant reasonably believes deadly force is about to be used against them. You can't use a gun against a punch.
Force must match the threat.
3. Imminency. The threat must be immediate or about to happen. Angela's notes are very clear here. A history of abuse, such as in battered women syndrome, does not negate the imminency requirement for the use of force. Force is only justified when the threat is immediate, not in anticipation of future harm.
Threat has to be happening now.
4. Non-aggressor. Generally, the defendant must not be the initial aggressor. If they were the initial aggressor, they must have safely withdrawn from the conflict and communicated that withdrawal to the other party before they can claim self-defense. You can't provoke a fight just to then kill someone in self-defense.
So proportionality and imminency are absolutely key. What about the duty to retreat? Are there different rules regarding whether you have to try and escape a deadly threat?
Yes, jurisdictions follow two main rules regarding the duty to retreat before using deadly force. 1. Majority rule, stand your ground. A majority of jurisdictions, often called stand your ground states, hold that there is generally no duty to retreat before using deadly force if you reasonably believe it's necessary to prevent death or serious bodily harm.
No duty to run away in most places.
2. Minority rule. A minority of jurisdictions impose a duty to retreat if one can do so safely, unless they are in their own home or place of business, a principle known as the castle doctrine.
Castle doctrine exception.
Right. For defense of others, the rules are generally the same as self-defense. You step into the shoes of the person being defended and can use the same level of force that the person being defended would be justified in using to protect themselves.
That makes defending others a very similar analysis to defending oneself. What about defense of property? When can you use force to protect your possessions?
For non-deadly force, it is generally permitted to defend property in one's possession from unlawful interference, such as trespass, removal, or damage. The defender must have a reasonable belief that such force is needed, and the need must appear imminent. Force should generally not be used if a simple request to desist would suffice.
Ask them to stop first, maybe.
Ideally, yes. Importantly, you generally cannot use force to regain property that has already been taken unless you are in immediate pursuit of the taker. The force used must always be proportional. Using excessive force, like shooting someone who is merely taking your laptop, will result in criminal liability for the defender.
So you can't shoot someone just for stealing a laptop unless they're threatening you personally. That leads to the follow-up question. Is deadly force ever permitted solely to protect property?
Generally, deadly force is not permitted to protect property alone. The value of human life typically outweighs the value of property. The narrow exception is when deadly force is justifiably used to prevent entry into a dwelling by a person who intends to commit a felony in that dwelling. In that specific scenario, if you reasonably believe the intruder intends a felony inside, deadly force to prevent entry may be permitted.
Only to stop a felony inside the home. Understood. Let's cover duress as a defense. When is this defense applicable?
Duress can act as a complete defense to a crime, but with one very significant exception. It is generally not a defense to intentional homicide.
Not for murder.
Right. For other crimes, a person is not guilty if they perform an otherwise criminal act under the threat of imminent infliction of death or great bodily harm to themselves or an immediate family member, provided they reasonably believe that such harm will be inflicted if they don't commit the act. Traditionally, threats to property alone were not sufficient for duress, but some states, consistent with the Model Penal Code, do allow threats to property to give rise to a duress defense if the value of the property clearly outweighs the harm done to society by the commission of the crime.
That exception for intentional homicide is crucial. Next, mistake, both mistake of fact and mistake of law. Let's start with mistake of fact.
Mistake of fact can be a defense if it genuinely negates the required mental state, it's reus, for the crime. The impact depends on the type of crime. For specific intent crimes, a mistake of fact can be a defense whether it is reasonable or unreasonable, as long as it genuinely prevented the defendant from forming that specific intent. For example, if you honestly but unreasonably thought someone else's coat was yours, that could negate the intent to steal for larceny.
Reasonable or unreasonable mistake works for specific intent.
For malice and general intent crimes, the mistake must be reasonable to serve as a defense. If your mistake was unreasonable, the defense will fail.
Must be reasonable for general intent.
And for strict liability crimes, mistake of fact is simply not a defense, as no mental state is required anyway.
And what about mistake of law? This seems much less likely to be a valid defense, given the general principle that ignorance of the law is no excuse.
You're right. Generally, mistake of law is not a defense. The legal system expects citizens to know the law. However, there are very narrow exceptions where it might apply, such as 1. Reliance on an official statement of law. If the defendant reasonably relied on an official statement of the law, for example, from a statute, judicial decision, or administrative order, that was later determined to be erroneous.
Relied on bad official advice.
Or 2. Law not published. If the law itself was not published or made reasonably available to the public, these are very rare and highly specific circumstances.
Finally, for defenses, let's discuss entrapment. When is this defense applicable?
Entrapment is a defense that applies when the criminal design or idea originated with the law enforcement authorities and the defendant was not predisposed to commit the crime.
Cops came up with the idea and you weren't inclined.
Essentially, yes. It's about whether the government induced an innocent person to commit a crime they otherwise would not have committed. If the defendant was already predisposed to commit that type of crime, even if police provided the opportunity, the defense will typically fail. The focus is on the defendant's predisposition before the government's involvement. 6. Criminal procedure essentials, safeguarding rights.
Now, let's dive into criminal procedure essentials, the crucial safeguards for individual rights within the criminal justice system. We'll begin with the Fourth Amendment. Search and seizure. What's the core principle guiding this amendment?
The Fourth Amendment primarily protects individuals against unreasonable searches and seizures by the government. The foundational principle is that, to be considered reasonable, searches and seizures generally require probable cause, especially when a warrant is involved. What constitutes a seizure itself is quite broad under the Fourth Amendment. Stopping a car is a seizure of the occupants, and arresting a person is a seizure of their person.
And for a warrant to be valid, we need probable cause. What exactly does that mean in this context?
Probable cause is a vital standard. It means there must be reasonably trustworthy facts and circumstances that would lead a prudent person to believe that a crime has been committed or that evidence of a crime would be found in a particular place. It's a lower standard than beyond a reasonable doubt, which you need for conviction, but a higher standard than reasonable suspicion, which is needed for a brief investigatory stop. It's a fair probability that a crime occurred or evidence exists.
Okay, probable cause. Now, what are the main exceptions to the warrant requirement that police can use to conduct searches or seizures without a warrant? Let's start with consent searches.
Consent searches are a major exception. They are permissible if the state can prove, by a preponderance of the evidence, that the consent was given freely and voluntarily and not coerced. Courts look at the totality of the circumstances to determine voluntariness, including factors like whether the suspect was informed of their right to refuse consent, though actual knowledge isn't strictly required.
So it has to be voluntary. What about roommates?
Right, a key point for co-occupant consent. If two or more co-occupants have authority over property and are present, and one consents to a search while another who is also present expressly refuses, the police generally cannot search. However, if only one co-occupant is present and consents, that consent is valid.
So if you're there and you say no, that usually trumps another's yes. What about a search incident to a lawful arrest? ALE. This seems like a very common police action.
It is indeed. The first prerequisite is that the arrest must be lawful. Once a lawful arrest occurs, police can immediately search the arrestee's person and any areas within their wingspan or immediate control.
Wingspan, what does that cover?
This wingspan means the areas in which the arrestee might gain possession of a weapon or destructible evidence. This includes items like a briefcase on their shoulder. If a person is arrested while in a car, police may search the passenger compartment if the defendant is not yet secured and could still access the car, or if the police have a reasonable belief that there's evidence of the crime for which they were arrested within the car.
What about searching the rest of the house if arrested at home?
Beyond the immediate area, if someone is arrested at home, police may conduct a limited protective sweep of other areas if they have a specific articulable suspicion that other dangerous individuals might be lurking. This sweep is strictly limited in scope and duration to places where people could be hiding, like a closet, but not dresser drawers. And finally, an inventory search is lawful once a person is at the police station and secured, allowing police to document personal property on the person and in a secured vehicle.
That covers a significant amount of ground for arrests. What about exigent circumstances? These are essentially emergency situations, right?
Exactly. Exigent circumstances justify immediate action without a warrant when there's an emergency that makes obtaining a warrant impractical or dangerous. Common scenarios include 1. Preventing destruction of evidence. A reasonable belief that evidence may be lost or destroyed if police wait for a warrant, like hearing, shredding papers, or drugs being flushed down a toilet during a raid.
Gotta act fast.
2. Danger to officers or public safety. For example, an officer seeing a crime in progress, like a stabbing through a window or hearing screams inside a home, indicating imminent danger or injury to someone inside. The warrantless search must be strictly limited to the duration and scope of the exigency itself. Once the emergency ends, the warrantless search must cease. Importantly, this exception generally does not apply for minor crimes where there's no immediate threat to life or serious evidence destruction.
And the automobile exception, why are cars treated differently under the Fourth Amendment?
The automobile exception is based on two rationales. The inherent mobility of vehicles, which makes it impractical to obtain a warrant before a car drives away, and the reduced expectation of privacy in a vehicle due as they are subject to government regulation. If police have probable cause to believe that an automobile contains seizable items, contraband, or evidence of a crime, they may search any part of the automobile where such evidence could reasonably be found, including the trunk and containers within it, without a warrant.
Then there's the plain view doctrine. This one seems like it comes up a lot in everyday encounters.
It absolutely does. For the plain view doctrine to legitimately apply, 3 elements must be met. 1. Lawful presence. The officer must be legally in the place from which the view is made. They can't violate the Fourth Amendment to get to that vantage point.
Got to be there legally first.
2. In plain view. The items must be in plain view, meaning readily observable without manipulating or moving other objects.
Can't move things around to see.
3. Immediately recognizable. The items must be immediately recognizable as subject to seizure, meaning the officer has probable cause to believe they are contraband, fruits of a crime, instrumentalities of a crime, or mere evidence without needing to further investigate or manipulate them. A crucial limitation is that police may not manipulate objects to ascertain their evidentiary value. If they have to move something to see what's underneath, it's no longer in plain view.
That makes perfect sense. What about pretextual stops? If an officer pulls you over for a minor traffic violation, but their subjective motive is really to investigate a more serious crime, is that constitutional?
Yes, it is. The Supreme Court has clarified that as long as an officer has a valid, objective, probable cause for a traffic violation, meaning a reasonable officer could have made that stop, the stop is constitutional, regardless of the officer's subjective ulterior motive. The stop is not rendered unreasonable merely because it served as a pretext for some other investigative purpose.
And some other special circumstances for Fourth Amendment purposes that Angela's notes highlight.
Angela's notes mention a few interesting applications. Taking DNA samples from arrestees for serious crimes has been deemed constitutional. However, warrantless access to historical cell phone location records violates the Fourth Amendment. The Supreme Court has ruled there's a reasonable expectation of privacy in that kind of extensive historical data.
Cell phone location data needs a warrant.
Generally, yes, for historical records. Finally, a practical tip. There is no reasonable expectation of privacy for garbage left for collection outside the curtilage of a home. Once it's at the curb, it's fair game for law enforcement to search without a warrant.
That's a lot to consider for search and seizure. Let's move to the exclusionary rule and fruit of the poisonous tree. What's the primary purpose of the exclusionary rule?
The exclusionary rule is a judicially created remedy whose primary purpose is to deter police and government agents from engaging in unconstitutional activity. It prevents the prosecution from introducing evidence that was seized in violation of the Fourth, unreasonable search and seizures, or Fifth, self-incrimination amendments in its case in chief. It applies to both state and federal criminal proceedings, but importantly, it does not apply to grand jury proceedings, meaning illegally obtained evidence can sometimes be used there. To invoke it, the defense must file a motion to suppress the evidence.
And the fruit of the poisonous tree doctrine extends this rule. How does that work?
Yes, it does. This doctrine extends the exclusionary rule to evidence that is derived from or obtained as a direct result of unconstitutionally obtained evidence. The idea is to prevent the police from benefiting from their initial illegal actions. The fruit is tainted by the poisonous tree. However, there's an important exception related to Miranda warnings. If police obtain an unwarned confession, a Miranda violation, but then properly warn the suspect and re-question them, the subsequent warned confession may be admissible if there was no deliberate question first, warn later scheme designed to circumvent Miranda. The court will look at the totality of the circumstances to determine if the subsequent confession was truly voluntary and untainted.
Okay, let's talk about Miranda warnings and the Fifth Amendment. When exactly are these warnings required?
Miranda warnings are absolutely mandated by the Fifth Amendment for custodial interrogations. This means both elements must be present, the suspect must be in custody, and they must be subjected to interrogation. If either custody or interrogation is missing, Miranda warnings are not required, and any statements made may be admissible.
Custody and interrogation, both needed.
Correct.
What are the key elements that must be conveyed in a Miranda warning?
The warnings, while not requiring exact verbatim wording, must substantially convey 4 core rights. 1. The right to remain silent. 2. That anything the suspect says can and will be used against them in a court of law. 3. The right to have an attorney present during questioning. 4. The right to have an attorney appointed if they cannot afford one.
How is custody defined for Miranda purposes? It's not just being physically restrained, is it?
No, custody is an objective test. A court asks whether a reasonable person in the suspect's circumstances would feel free to decline the officer's requests or terminate the interrogation and leave. The environment must present the same inherently coercive pressures as a station house questioning. Routine traffic stops, for instance, are generally not considered custodial, even though your movement is restricted, because the detention is brief and non-threatening.
And interrogation. What specific actions or words by police would constitute interrogation?
Interrogation means either express questioning by the police or any words or actions by the police that they should reasonably know are likely to elicit an incriminating response from the suspect. It's not just direct questions. It can be subtle psychological ploys or leading statements designed to get the suspect to talk about the crime.
What about waiving Miranda rights, and how clear must the suspect be if they want to invoke their rights?
The prosecution bears the substantial burden of showing that a waiver of Miranda rights was voluntary, knowing, and intelligent by a preponderance of the evidence based on the totality of the circumstances. It's important to remember that a defendant's actual knowledge of their rights, perhaps from prior arrests or legal education, is not a substitute for the police providing the warnings. They must be explicitly given.
Cops still have to read them the rights.
Yes. As for invoking rights, the suspect must do so clearly and unequivocally. Ambiguous statements like, "I think I need an attorney," are generally not sufficient to invoke the right to counsel. If a suspect unequivocally invokes their right to remain silent or to counsel, the police must immediately cease interrogation. However, statements that are genuinely volunteered by a defendant and are not in response to police interrogation are admissible, even if no Miranda warnings were given.
That's a critical distinction to keep in mind, especially with the unequivocal standard. Now let's turn to the right to counsel under the Sixth Amendment. When does this crucial right actually attach?
The Sixth Amendment right to counsel is a very important offense-specific right that attaches once adversarial judicial proceedings have begun against the defendant. This typically means upon formal charge, indictment, or preliminary hearing.
Once charged.
Right. It's offense-specific, meaning it only applies to the specific crime for which the defendant has been charged. For example, if a suspect is indicted for assault and has a lawyer for that charge, police can still question them about unrelated burglaries they haven't been charged with, without violating the Sixth Amendment right to counsel for the burglaries.
So it's very specific to the charged offense, not a blanket right. And how does a violation of this right occur?
A violation of the Sixth Amendment right to counsel occurs if a secret agent, acting on behalf of the government, like an undercover police officer or an informant instructed by police, deliberately elicits incriminating statements from the suspect in the absence of counsel after the Sixth Amendment right has attached for that specific charged offense. This means the government cannot try to secretly obtain information about a charged crime from a defendant who has the right to counsel for that crime. For example, placing an undercover cop in a suspect's jail cell to get them to brag about the charged crime would violate this right because it's a deliberate elicitation of information.
What about ineffective assistance of counsel? This is evaluated under a two-part test known as the Strickland test, correct?
Yes, the Strickland test sets a very high bar for proving ineffective assistance of counsel. It has two prongs, both of which the defendant must satisfy. 1. Deficient performance. The defendant must show that their attorney's performance fell below an objective standard of reasonableness, meaning the errors were so serious that counsel was not functioning as the counsel guaranteed by the Sixth Amendment. There's a strong presumption of effective performance that the defendant must overcome.
Lawyer messed up badly.
And 2. Prejudice. The defendant must then show that there is a reasonable probability that, but for the attorney's deficient performance, the outcome of the proceeding would have been different. This means the errors were so severe they undermine confidence in the outcome. An important application of this, as noted in Angela's materials, is that defense counsel has an affirmative duty to advise non-citizen clients about the deportation risks of a guilty plea. Failure to do so can be considered deficient performance.
That seems like a very difficult bar for a defendant to meet. What about a defendant's right to represent themselves? How does one validly waive the right to counsel and proceed pro se?
For a defendant to validly waive their Sixth Amendment right to counsel and represent themselves, the waiver must be voluntary, knowing, and intelligent. This means the defendant must be shown to have an awareness of the magnitude of the task confronting them and the potential disadvantages and risks of representing themselves. Simply making the defendant aware of their constitutional right to counsel is insufficient. They must truly understand the implications of what they are giving up by choosing self-representation.
And when does the Sixth Amendment right to counsel not apply? What are some situations where a defendant generally doesn't have this right?
The Sixth Amendment right to counsel does not apply to certain critical stages or investigative actions. For instance, it does not apply to the taking of non-testimonial physical evidence like blood samples, handwriting samples, or fingerprints from a defendant.
Physical evidence gathering.
During pre-charge lineups and pre- or post-charge photo identifications. During a brief recess while a defendant is testifying at trial. During parole and probation revocation hearings. And importantly, a witness subpoenaed by a grand jury does not have a constitutional right to counsel inside the grand jury room. They can consult with counsel outside, but not within the proceedings.
That's a comprehensive list. Moving on to fair trial protections, let's start with guilty pleas. What are the fundamental requirements for a guilty plea to be valid?
Guilty pleas are a cornerstone of the justice system, and they must be entered voluntarily and intelligently. This means the defendant must have a full understanding of the nature of the charge and the direct consequences of pleading guilty, including the maximum possible sentence and the rights they are waiving, like the right to a trial. The court is obligated to ensure the defendant knows what they are doing before accepting a plea.
And severance. When might co-defendants be tried separately rather than together?
If two or more co-defendants are charged and tried together, one defendant can request severance, meaning to be tried alone, if they would be unfairly prejudiced by a joint trial. This often arises when one co-defendant's confession implicates the other, and the confessing defendant is unavailable for cross-examination. The specific facts of the case will dictate whether such unfair prejudice exists, which would then mandate separate trials to assure a fair process for all.
What about the judge themselves? What's required for judicial impartiality?
For a fair trial to occur, the defendant has a fundamental right to an impartial, unbiased judge. This means the judge must not have any personal stake in the outcome of the case or any demonstrable bias against the defendant or the prosecution. It's a critical component of due process that ensures a neutral arbiter.
And competency to stand trial.
A defendant must be competent to stand trial. This means they must have a sufficient present ability to understand the nature and object of the charges against them and be able to consult with their lawyer with a reasonable degree of rational understanding. What might surprise some listeners is that a defendant may even be given drugs to achieve competency if it's deemed medically necessary for them to participate meaningfully in their own defense and thus ensure a fair trial.
Next, jury trial rights. When does a defendant have a constitutional right to a jury trial?
A defendant has a constitutional right to a jury trial under the Sixth Amendment if the offense with which they are charged carries a potential sentence longer than 6 months. For petty offenses with a maximum sentence of 6 months or less, there's generally no right to a jury trial.
More than 6 months potential sentence.
Right. The jury itself should be drawn from a fair cross-section of the community, meaning that exclusion of potential jurors based on characteristics like race or gender violates the Equal Protection Clause.
And what about unanimity for jury verdicts? Does a jury always have to be unanimous in its decision?
Not always, and this is a key distinction for the bar exam. State trials. For state criminal trials, if the jury has 6 members, the verdict must be unanimous. However, if it's a 12-member jury in a state trial, the verdict does not necessarily need to be unanimous. State law controls this, and some states permit non-unanimous verdicts.
Depends on the state for 12-member.
Federal trials. For federal criminal trials, a 12-member jury must render a unanimous verdict. This is a strict requirement in the federal system.
That's a great distinction to remember for state versus federal cases. What about public trial rights?
Generally, a defendant has a constitutional right to a public trial in all criminal prosecutions. This promotes fairness and transparency in the justice system. The press can typically attend, with the notable exception of grand jury proceedings, which are generally secret. A judge can close a trial to the public only if there's an overriding interest that necessitates the closure, and the closure must be no broader than necessary to serve that overriding interest. The specific facts of the case will indicate if such an overriding interest exists.
Let's discuss the right of confrontation under the Sixth Amendment. What's the core of this right?
The core of the Sixth Amendment right of confrontation is the defendant's right to confront and cross-examine all witnesses who testify against them, even for out-of-court statements admitted into evidence. This right ensures the reliability of testimony and allows the defense to challenge adverse evidence. A key application of this right involves co-defendant confessions. An extrajudicial confession, a confession made outside of court, by one co-defendant that implicates another co-defendant generally violates the Confrontation Clause and is inadmissible against the non-confessing defendant unless the confessing co-defendant is available to testify at trial and be cross-examined. If they are not available for cross-examination, their confession cannot be used against the other defendant.
So the co-defendant has to be available to cross-examine?
Usually, yes, for their confession to be used against the other defendant.
What about other out-of-court statements that aren't confessions? When are those admissible or inadmissible under the Confrontation Clause?
This is a complex but vital area. The admissibility depends on whether the out-of-court statement is testimonial or non-testimonial. Admissible, non-testimonial. If the statement was not testimonial, it generally can be admitted under a hearsay exception without violating the Confrontation Clause. A statement is considered non-testimonial if it was made during an ongoing emergency, like a 911 call describing an act of crime, or made during a police investigation primarily to help resolve an ongoing situation. For example, identifying an assailant fleeing the scene. The primary purpose of the statement must be to enable police assistance to meet an ongoing emergency.
Made during an emergency.
Inadmissible, testimonial. If the statement was testimonial, meaning it was not made during an ongoing emergency, or it was made primarily to help police in an investigation that is not ongoing, for example, recounting past events to gather evidence for prosecution, or it's a formal declaration, then it is inadmissible if the declarant is unavailable to testify at trial and has not been subject to prior cross-examination by the defendant. Business records, by their nature, are generally considered not testimonial because their primary purpose isn't to create evidence for prosecution.
Okay, let's move to double jeopardy under the Fifth Amendment. What's the core principle that this protection ensures?
The core principle of double jeopardy is that it prevents a person from being tried twice for the same offense after legitimate acquittal or conviction, or subjected to multiple punishments for the same offense. This protection safeguards against government harassment and ensures finality in criminal proceedings.
And how is same offense determined for double jeopardy purposes?
The primary test for determining whether two crimes are the same offense is the Blockberger test. Under this test, two crimes are not the same offense if each crime requires proof of an additional element that the other does not. This holds true even if some of the same facts are used to prove both crimes. If one crime can be proven without proving an element of the other, they are considered separate offenses.
Each needs a unique element.
Correct.
What about greater and lesser included offenses? How does double jeopardy apply there?
If there's a conviction or acquittal on a lesser included offense in the first proceeding, the double jeopardy clause bars a subsequent prosecution for the greater offense. The same principle applies in reverse. A conviction or acquittal on a greater offense bars a second prosecution on the lesser included offense. Critically, a conviction on a lesser included offense actually constitutes an implied acquittal of the more serious offense. For example, if a defendant is charged with first-degree murder but found guilty only of second-degree murder, they cannot thereafter be tried for first-degree murder in a new trial for that same act.
When does jeopardy actually attach? This seems like a key point in determining when the protection begins.
Jeopardy officially attaches when the jury is sworn in during a jury trial or when the first witness is sworn in during a bench trial, a trial conducted by a judge without a jury. Importantly, jeopardy does not attach at preliminary hearings or grand jury proceedings. This is why the same charges can be brought against a defendant at more than one grand jury proceeding without violating double jeopardy.
That explains why grand juries can indict multiple times without double jeopardy issues. What about separate sovereigns? Does double jeopardy apply if two different states or a state and the federal government try a person for the same crime?
No, the separate sovereigns doctrine is a key exception. There is no double jeopardy violation if two different states try a person for the same crime, or if a state government and the federal government try a person for the same underlying conduct. This is because each sovereign, each distinct governmental entity, has its own laws and can prosecute offenses against its own laws independently, even if the facts overlap.
State and feds can both prosecute. And finally, a mistrial. When would a mistrial trigger double jeopardy protection, preventing a second trial?
Generally, if a mistrial is declared without the defendant's consent, a second trial is barred by double jeopardy unless there was manifest necessity for the mistrial. Manifest necessity is a high standard, meaning there was no other reasonable alternative to terminating the trial. For instance, a judge's inability to complete a trial due to unforeseen circumstances, like a sudden death in their family, without the defendant's consent would typically not constitute manifest necessity, and a second trial would be barred. This protects the defendant's valued right to have their trial completed before the first tribunal.
Moving on to burdens of proof and persuasion. What's the prosecution's burden in a criminal case, and how rigorous is it?
The prosecution bears the unwavering burden of proving every element of the crime charged beyond a reasonable doubt. This is a fundamental and constitutionally mandated principle of criminal law, designed to protect the presumption of innocence.
Beyond a reasonable doubt, very high standard.
Extremely high.
And for the defendant, if they raise an affirmative defense, who carries the burden there?
If the defendant raises an affirmative defense, such as self-defense, duress, or insanity, they typically bear the burden of proving that defense. This burden is usually met by a preponderance of the evidence, meaning they must show it's more likely than not that the defense applies.
What about an alibi? Who has the burden to prove or disprove an alibi?
The prosecution has the burden to disprove an alibi beyond a reasonable doubt. An alibi isn't considered a traditional affirmative defense in the same way as, say, self-defense. Instead, an alibi directly negates an essential element of the crime, specifically that the defendant committed the act. Therefore, due process prevents imposing upon a defendant the burden of proving their alibi. The prosecution must show the defendant was present and committed the crime.
Prosecution has to disprove the alibi and the burden for insanity.
The state can constitutionally require the defendant to bear the burden of proving insanity, typically by a preponderance of the evidence. As we discussed earlier, a state even has the constitutional authority to eliminate the insanity defense entirely, though few choose to do so.
Our final topic in criminal procedure, sentencing. What kind of judicial discretion do judges have when determining a sentence?
Sentencing judges have considerable discretion in determining an appropriate sentence within statutory or constitutional limits. They are not confined strictly to the evidence presented at trial and can consider a wide range of information about the defendant's life, character, criminal history, and any mitigating or aggravating circumstances. This allows for individualized punishment, meaning the judge can tailor the sentence to the specific defendant and the unique aspects of their crime.
Are there constitutional limits to sentencing, particularly under the Eighth Amendment's prohibition against cruel and unusual punishment?
Yes, absolutely. The Eighth Amendment does place limits on sentencing. For instance, it prohibits the execution of people with severe intellectual disabilities. Additionally, Angela's notes highlight that a life without parole sentence is not constitutionally permissible for a juvenile defendant convicted of a non-homicide offense. The Supreme Court has recognized that children are constitutionally different from adults for sentencing purposes in these specific contexts.
Big limits for juveniles and intellectual disability.
Yes.
And finally, what's the jury's role in sentencing enhancements? When does the jury get involved in determining factors that increase a sentence?
This is a very important point that has evolved through Supreme Court jurisprudence. If a finding beyond the elements of the crime exposes a defendant to a sentence beyond the statutory maximum for that crime, that finding must be determined by a jury and proven beyond a reasonable doubt. This ensures that any facts that significantly increase the potential punishment are subjected to the higher standard of proof and jury determination, rather than being decided solely by a judge, upholding the Sixth Amendment right to a jury trial. Outro.
Well, we've covered an incredible amount of ground today on criminal law. From the foundational elements of crimes to complex defenses and the intricate dance of criminal procedure, we really hope that Angela's comprehensive notes have given you a clearer, more insightful path through some of the most critical criminal law topics for the bar.
Indeed. This kind of focused and detailed discussion, built on Angela's excellent outlines, is designed specifically to help you connect the dots, understand the nuances, and remember the vital details, truly providing that essential conceptual understanding you need for the exam.
Speaking of Angela, we want to extend a huge thanks to her for her incredible criminal law notes, which are truly the backbone of this entire podcast series.
And just a few important housekeeping points as always. Firstly, please remember that Angela is a law student, just like many of you who are studying for the bar. She's not an attorney, and she hasn't passed the state bar yet.
And to be absolutely clear, Angela is not giving legal advice, nor is this podcast. Nothing here should be construed as legal advice. Similarly, AI is not a substitute for your diligent study for the bar exam. Think of us as an aid, a helpful tool, rather than a shortcut to bar exam success.
That's right. This podcast is intended to supplement your learning and should definitely not be the only way you're studying for the bar. Your comprehensive study plan is key.
Also, as AI, we aren't always correct. Sometimes we make mistakes. Angela does try to fix any errors that happen. Her notes may be excellent, but even law students, and indeed even AI, can have a slip. We always do our best to correct any wrong information as quickly as possible.
This podcast and the entire series is an academic, non-commercial venture by Angela. It's strictly for educational purposes. Angela makes no money from this podcast, and thus she makes no guarantees on its accuracy.
And finally, when you're driving, the most important thing is always to be safe on the road. Please don't cause a tort while listening to criminal law.
Just a reminder on how to contact Angela. You can email her at podcast@studyforthebarinyourcar.com for podcast-related matters. Or, if you're an attorney needing law clerk assistance with research or writing motions, you can reach her at hello@legalwriterandlawclerk.com.
And now, as tradition dictates, for a cheesy constitutional law or First Amendment joke, why did the police officer get confused at the bakery? Because he thought the baker was engaging in an unreasonable yeast and seizure.
This is Claude, your AI host, signing off.
We'll see you on the next podcast. Thanks for listening. Bye.